Yes, Your Honor.
Ms. O'Brien?
Yes, Your Honor.
All right, we're back on the record. Mr. Huckabee?
To answer your question, Your Honor, I spoke to my client. My client believes that a ad litem would be beneficial. However, due to the child being 16 and a half, and by the time we get an ad litem appointed to get up on the case, financially, I don't know what can be done in the next year and a half.
Are you requesting the appointment of an ad litem?
No, Your Honor.
All right, Mr. Huckabee, you may close.
Your Honor, we believe this case is a prime example of what parental alienation is. Mr. Holcomb admitted under oath that he violated every single allegation I put into my pleading for motion for enforcement. Mr. Holcomb says he believed that my client gave up his visitation. However, the court has seen the text messages. Not one time did my client state she was giving up her visitation. Secondly, not one time after July 2nd did my client ever state he was giving up visitation. And Mr. Holcomb stated, I had no clue until October 9th. However, he admitted that he refused visitation after October 9th for the next 2 weekends, which is my client. Your Honor, the court took judicial notice that Miss Bailey was given makeup time due to my client not getting visitation prior. And this is continuing on. Mr. Holcomb is preventing my client from exercising visitation. The court ordered that the child get into counseling. Here it is 3 months later, he's taking the child one day. Your Honor, and we would request that if the court orders therapeutic visits, we have no assurance that Mr. Holcomb will take the child to those counseling sessions. And the only way we can assure it is by finding Mr. Holcomb in contempt and having a enforcement mechanism that he has to, because apparently the order is not good enough. Also, in our conversation, it is apparent that Mr. Holcomb has talked to the child about the court papers in the court documents. It's apparent that Mr. Holcomb testified he was on the couch with his daughter and she overread. That's not what was relayed in our messages, Your Honor. So it's apparent that Mr. Holcomb was showing the child text message in an attempt to alienate Miss Bailey. Thirdly, the child, very bright child, and not to talk negatively about the child, but she even testified that she was the one chasing my client's husband around, or following behind them, which is not what the police report stated. Thus, if the child even admits that the police report's not correct, then the allegations in the police report aren't correct. We believe this was a child who has been under the thumb of her father, being allowed to do whatever she wants to do whenever she wants to do it. And when Miss Bailey asked, hey, get off your phone, we're hanging out as a family, she got upset. And when she didn't get her way, she jumped into Miss Bailey's bad, Miss Bailey's bad, Miss Bailey's bad. And, Your Honor, that is, like I said, prime example of parental alienation. My client needs a relationship with the child. The child needs a relationship with my client. My client is asking for the 2 months makeup visitation. She's more than willing to go to counseling. Mr. Holcomb canceled 2 of the counseling sessions, and it took him 2 months to get another one in. He has no incentive to, child into the counseling needed. And we believe that Mr. Holcomb should be, found in contempt for violation of the court orders. He should be, that commitment should be probated and, for insurance that he follows any court orders this court makes. I would reiterate my objection to the motion to modify being timely filed as not within, no material substantial change since the date of the order. And that my client should be awarded the $3,500 in attorney fees that she's had to file to get into this place. And, Mr. Daly, or Mr. Holcomb also testified that at no time did my client ever say, I'm not picking the kid up, I'm canceling my visitation. He keeps bringing back the text messages, and the text messages don't even say that. Thus, we would request that Mr. Holcomb be found in contempt, my client get the 60 days makeup time that she is entitled, that be run concurrently, so that they can build that relationship and my client have the ability to have therapeutic visits with the child to supplement her normal visitation. And we request that the court deny the motion to modify as pled to by Mr. Holcomb. Thank you.
Ms. O'Brien?
Your Honor, I believe the evidence has established that Ms. Bailey told both the child and Sean that she wanted to relinquish her parental rights on 2 different occasions. She specifically told the child that she no longer wanted to visit with the child on June 12th. She's failed to communicate with either Sean Holcomb or the child since July 2nd. She's led both parties to believe that she had abandoned her intention to exercise her visitation. And I think she purposely did so, Your Honor, to get Mr. Holcomb in trouble. Rather than trying to rectify her relationship or bridge the gap between her and Haven, she chose to file a motion for enforcement, trying to get Sean put in jail. I don't think that's indicative of a mom who really wants to rebuild a relationship with a daughter that is going through a lot of turmoil. In addition to that, Your Honor, I do believe we've met the burden of proving a material and substantial change in circumstances. Since the original agreement was announced on the record on May 20th of 2020, I believe it was actually May 14th of 2020. Since that order was announced on the record, there have been several incidents at the residence of Ms. Bailey. Ms. Bailey has been in a physical altercation Mr. Bailey has been in a physical altercation with Haven. Their police have had to be called. In addition to that, Ms. Bailey has ended visitation twice before the visitation was supposed to be ended. I believe, Your Honor, that it's in the best interest of the child that the orders be modified to allow the child to have some type of sense of security while she's visiting with her mother. I don't think this is a case that it would be in the best interest of the child for Ms. Bailey to have unsupervised visits at this point in time. Haven did indicate that she did not feel that counseling would be beneficial between her and her mother. Your Honor, I don't know what else the court can do to try and rectify that relationship and at the same time protect Haven. That's all I have, Your Honor.
Rebuttal, Mr. Huckabee?
Yes, Your Honor. In response to Ms. O'Brien's statement that she ended visitation twice, that is incorrect. There was one incident on the June.
I remember the testimony.
And secondly, at no time did my client ever tell the child or Mr. Holcomb that she was giving up her visitation. If you read the text message that she wrote Mr. Holcomb, it is very clear that she never said, I'm giving up visitation. And to reiterate, if Mr. Holcomb truly believed that he was giving up visitation, then when she got served on October 9th, he was aware that the weekend of October 9th, 10th, 11th, and the weekend of 16th, 17th, 18th, My client wanted her visitation, and he continued to refuse to provide the visitation. Your Honor, this is a child who, after reiterate, this is a child. A child is under the court orders until the child is 18 or emancipated, and this child is not emancipated. Mr. Holcomb and the child believe that they can tell the court, we don't got to follow this. And if the child was really as in fear and in danger as Mr. Holcomb is now alleging, he could have filed a motion for modification on July 3rd, but he waited. He didn't do anything until he was served with an enforcement, and then when he served the enforcement, then he filed it. That is not a child who's in danger or Mr. Holcomb protecting the child. That is Mr. Holcomb saying, I'm not going to do anything. I'm going to keep telling the courts don't matter. The order doesn't matter. Oh, let me file something now. If he was really protecting his child, he could have filed something on July 3rd, but he chose not to. And now he is using it to protect himself from the fact that he violated the court orders.
First of all, I do find, and I know that Haven Bailey's testimony was not recorded, but I do find her testimony to be credible. Miss Bailey? Okay. All right. One thing is Mr. Huckabee made a very good point, is we're talking about a 16-year-old teenage girl, and I've had 16-year-old teenage girls in my house before, and I understand that there's some things that are difficult with handling teenage girls, and I'm not going to try to tell you that I can do it. That there are some things that a judge can do, and there are some things that a parent has to do. And it seems to me like both of you, to a certain degree, are asking me to decisions as opposed to legal decisions. It's not what I'm going to do. I'm not going to do that. Whether or not you have a phone in your house, unless you can show me how it's a danger, that's going to be between you and your daughter. I'm not going to try to be a parent. I've done that and made my own fair share of mistakes with my own children. I don't need to make mistakes with other people's children. However, I do control things like possession and access and a few things like that. And so, as far as Mr. Huckabee's motions for contempt, I'm going to take them, each of them, all of them, under advisement. I'm going to take his request for attorney fees under advisement. I am on a temporary basis going to suspend visitation between Haven and her mother. I am ordering that Miss Bailey and Haven be in counseling together with a counselor. Mr. Wood could do it, and I know that sometimes counselors take the position that if I am counseling with one person individually, I don't want to be the joint counselor. That's kind of a different counselors are different ways. If he doesn't think he can do it, then I am ordering another counselor, and that the two counselors will communicate with each other. I am ordering that so that they're not worried about HIPAA and those kind of things. That there is a court order ordering that they communicate together. Now then, again, I know that there are teenagers, juniors in high school have very busy school schedules. The court order for counseling supersedes them. It may not make anybody very happy, but I can control school and I can control things like that. If we need to have an order from the court to the school, I will do that. I want Haven in counseling with Dr. Wood or Mr. Wood, David Wood. I want Miss Bailey and Haven to be in counseling together. Now, Miss Bailey, I know that you're wanting me to order Haven to just go live with you. You've asked it, and I'm finding at this point in time that is not in her best interest at this time. You have some work to do as a mother to repair your relationship with your daughter. And I'm not saying that's easy. I'm not saying that Haven is not also part of it, and that Mr. Holcomb is not part of it. I can order you both not to talk about the hearing. I can order you both, and I am ordering you both not to talk about the court case or about each other. Don't do it. Mr. Holcomb, I'm ordering you to make sure that Haven has each counseling session. Now, if it takes a little adjustment, that's fine. But it's not going to be put off from August to October. That's not going to happen. Mrs. O'Brien will explain to you what it means when I say that I'm taking things under advisement. And I think she'll explain to you very well what that means. Because if you're in jail, where's Haven going to be?
Yes, sir.
And I'm not going to have that. I understand that there have to be some adjustments. I understand that. But from August to October is ridiculous. It can be done quicker than that. Now, if Mr. Wood and if there is another counselor recommends additional access between Haven and Miss Bailey, I hope that Mr. Huckabee and Miss O'Brien, that the two of you can work towards getting that done without another court hearing. Now, if it can't be, if there's a reason why, hey, we know what the doctor said, but he doesn't understand this part, I will listen. I will. Because I know sometimes that's very real. But the inability to work together is not going to do either one of your clients a favor. If you come back in with an uncooperation situation, the thing about it is if you come back in and there's an allegation that neither one of you are cooperating, I will take that into consideration when I consider the best interest of the minor child. Is that Haven Miss Bailey, Haven, I find Haven is afraid to go to your home. And that's wrong. That's not good. And that indicates that there is a problem that we need to fix. And I'm sorry, but that is where I am. And I want you to work on that relationship. All right, those are my temporary orders. Are they sufficiently unclear for you to manage to wade through them, Ms. O'Brien?
I think they are, Your Honor. I think I can get through them. If not, I will ask for some clarification if needed.
And if you will circulate those to Mr. Huckabee. If y'all on the counselor, if Mr. Wood can do it, that's fine. If we need to include another counselor, y'all talk to me. Y'all can submit. If y'all can't agree on a counselor, submit names to me, and I will pick another counselor. I want that to happen quickly.
I'll get it done this week, Your Honor.
Mr. Huckabee, is there anything else I can clear up at this time?
No, Your Honor.
All right, thank you. I'm going to end our meeting at this time.